Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on May 12th. That's Friday, 2023. You'll be hearing this in a few days when it is released. But joining me here on May 12th, 2023, are two of my Institute for Justice colleagues who are going to tell us about a case from the Ninth Circuit and a case from the Fifth Circuit. Thanks, everyone, by the way, who so far has either downloaded for free or purchased my book online. Thank you very much for all the support. Been overwhelmed with the response for the book. It's been fun. But we've talked enough about baby Ninth Amendments lately here on Short Circuit. It's time to get back to the Federal Courts of Appeals. And for that, I am joined by Justin Pearson from our Florida office and Chrissy Hebert from our Texas office. So welcome to both of you.
Hey, Anthony.
Thanks, Anthony. Congratulations, too.
Thanks. I appreciate it. Well, let's start out west. For some reason, it's out west. I don't really get why. With Justin and this case from the Ninth Circuit, which sounds like kind of a Massachusetts like history melodrama, Robert F. Kennedy Jr. versus Elizabeth Warren. But actually, it's not really all that, is it?
No, not really. And before I start ranting and raving, which will happen eventually, I do want to point out that the panel, at the end of the day, probably got the ruling correct. It's just that the opinion was so dismissive that I think it really exemplifies a huge blind spot that the federal judiciary tends to have, especially when a government official is one of the parties. And so it was really the dismissiveness of the majority opinion that really bothered me and what I really want to talk about. But first, I should give some background to what's going on here. Robert F. Kennedy Jr., undoubtedly to the chagrin of his relatives, is a bit of a COVID conspiracy theorist. And he wrote the foreword to a book written by fellow COVID conspiracy theorists. I have not read the book. Maybe it's brilliant. I suspect that I probably disagree with some of the things that it says, but that's not really the point, right? That's neither here nor there for the purposes of this First Amendment challenge. In reaction to the book, Senator Elizabeth Warren sent a scary letter to Amazon, complaining that Amazon's algorithm was referring people to the book, right? And she phrased the letter, which I'm sure her staffers wrote, but she phrased the letter in the form of a request. But then she also talked about how this conduct was potentially unlawful. And just, I think when most reasonable people get a letter, or most businesses get a letter from a relatively powerful, even comparatively speaking, U.S. senator saying that they're engaged in potentially unlawful conduct and requesting that they answer 4 questions posed in that letter within 14 days, it's going to get your attention in a way that a letter from someone who doesn't have the power of the government behind them, wouldn't. And so in reaction to the letter, Amazon stopped advertising this book. And I should point out, Senator Warren also posted the letter to her website. The day after she posted it, Barnes & Noble decided to do the same thing. Perhaps just a coincidence that it was the next day, but it seems like a pretty big coincidence. So anyway, Robert F. Kennedy Jr. and the authors of the rest of the book, like I said, he wrote the foreword, they bring this First Amendment challenge arguing government coercion, right? And of course, there's the famous Bantam Books case about, the government trying to coerce sellers of books to as a way to stifle, free speech and to censor the actual authors, even without going after the authors directly. And so they brought a case kind of under that logic, saying that this letter was coercive and caused Amazon and Barnes & Noble to, take these actions that will make it so that fewer people read the book. And the district court ruled against the plaintiffs when it came to their motion for preliminary injunction, right? And this is up on interlocutory appeal from the denial of the preliminary injunction ruling. And the district court did something that's going to become important for the purposes of the Ninth Circuit opinion, which is the district court not only denied the PI, but the district court also said that the plaintiffs failed to even raise a serious question of a First Amendment violation. And that's because of precedent about the standards that have to be met to obtain a PI, right? Typically, one of the prongs is likelihood of success on the merits, but then there's this also some precedent saying that if you don't achieve that level for that prong, as long as you raise a serious question, you can still sometimes get a PI if you really exceed the other prongs of the analysis. And the district court said that this claim of coercion wasn't even a serious question, right? It didn't call it frivolous, but it's kind of in that ballpark. And so the appeal goes up to the Ninth Circuit, and the panel agrees that the PI should be denied, but they disagree about whether a serious question was raised. Two of the panelists say that no serious question was raised. And again, I thought this was very dismissive in a way that I'll get to in a minute. But I should point out that Judge Bennett wrote a concurrence saying that he still would have affirmed the denial of PI because the district court judge did not abuse their discretion, but that he thought that the majority opinion was wrong in saying that there was no serious question raised and that he could see how reasonable people could view this as coercion. And I'll go through the four prongs of the analysis for coercion in a second, but really, again, going back to my opening, the reason I wanted to flag this was because through this entire analysis, through this entire four-pronged analysis, the majority opinion is extremely dismissive in a way that I think illustrates a problem that I know has been talked about before on this podcast, which is the disproportionate number of former government lawyers who are judges compared to former public interest lawyers or defense attorneys. And so I'm not even criticizing the specific judge who wrote this because I think it's emblematic of a much larger problem. But the judge who wrote this opinion is a former government lawyer. I looked it up. In a federal judiciary disproportionately filled with former government lawyers. Our friend Clark Neely, who's now at Cato, I think, has said that it's a 7-to-1 ratio, or
something like
7
that, yeah.
former government lawyers and prosecutors for every one criminal defense attorney or public interest lawyer. And so when you have that imbalance, you get these incredible blind spots where when you read this majority opinion, it's just clear that the author cannot fathom how anyone could think that this was coercion, right? Meanwhile, I suspect that if you ask the majority of ordinary Americans, they could very easily see how someone could view this as coercion. And so I'm not even necessarily saying that at the end of the day, they got the analysis wrong. Based on the precedent, it might not have crossed the line into what the precedent considers to be coercion. But this was, I think, a much closer call than the majority opinion would have you believe. And it's a shame that the opinion was so dismissive. In fact, it was so dismissive that it kind of makes it hard to really say if the PI should have been granted or not. But what I can tell you is that this majority opinion was just a little off. And so I'll go through the four prongs and kind of what the court said before hopefully talking about Judge Bennett's excellent concurrence in a second. And so first, the first prong was, the government officials' word choice and tone. And, what the court said was, the tone of the letter was in the form of a request, right? And so even though it uses words like potentially unlawful, because of the word choice and tone that was picked, under this prong of the four-prong analysis, it leads you to think that what's really going on here is a government official trying to persuade someone, not coerce them. But again, it's this kind of lack of reality going on here where Elizabeth Warren has, I'm sure, many staffers. I don't know firsthand, but I'm willing to guess that, including people with law degrees. And when you read the precedent, it's not that hard to choose the words that the president says fall on one side of the line or the other. And so, and even with that in mind, to then say that Amazon's doing something that's potentially unlawful, you think would still possibly have caused them to at least arguably cross the line. But no, the majority panel doesn't think it's even plausible and the words potentially unlawful don't change the fact that this was a very polite letter. And going on to the second prong, regulatory authority. Again, the panel, is shocked that someone could think that a letter from a sitting U.S. senator, could give someone the appearance or the impression that Elizabeth Warren has any power whatsoever. They point out that she doesn't have any unilateral power, which, right, is true to a degree. And then they just drop a footnote talking about when the events happened, she was on the Senate Finance Committee that was holding hearings investigating Amazon for antitrust violations. And just drop that in a footnote, right? Okay. And then go on, saying how this isn't even a close call. She has no authority. A senator can't do anything on their own. She's a high-ranking member of, the party that was in control of Senate at the time, but she's got no power. Okay, fair enough. Move on to the third prong, right? The perception of the recipient. And again, it's just this kind of lack of touch with reality where, or willingness to kind of bend over backwards to make excuses for a government official, where they say, well, sure, Amazon actually changed after they received the letter. And sure, the very next day after it was posted, Barnes & Noble, changed their actions as well. But we don't know for sure that it was because of the letter. It could have been for other reasons. And oh, by the way, even if it was in part because of the letter, maybe it was because they found the letter persuasive, not because of any coercive aspects. And which brings us to our final prong, whether the letter expressly states that there will be adverse consequences. And to be fair, the panel does point out that you can have coercive language that doesn't say or else. You can have language that says, "Oh, that's a nice business you got there. Shame if something were to happen."
Yeah,
to
that's
it.
exactly what I was thinking of. The letter. I mean,
right,
mob bosses
exactly.
never used the language that would satisfy this prong.
Right. And so, to be fair, the panel does point out that you don't need to say it expressly. You can say it the way, Anthony, that you and I just said. But then they go through the analysis as if they forgot that sentence that they had just written, and point out that the letter didn't say any express threats, which in some ways is even scarier when it's coming from a senator in our omnipotent, unfortunately, U.S. government. And so then what they do is then they end up agreeing with the district court's conclusion that this wasn't even a serious First Amendment question that was raised, let alone one with a likelihood of success on the merits. And so they didn't really have to get into the other prongs of the PI analysis. Again, it's not even that they were wrong to affirm the district court, but it's just every step along the way, you could just see how unfair and unbalanced the analysis was, and I'm not again trying to insult the judges. It's just you see this problem over and over again when you have such a disproportionate makeup of the judiciary, where just you have so many more former government lawyers than anyone else, and I just think that implicit bias just kept working its way into the opinion in a way that really made it hard to tell what the result should have been if it had been presented more fairly. Although I'm not necessarily, again, saying that the panel was even wrong. I just didn't like the way the opinion was written. Now that brings us to Judge Bennett's, great concurrence, which he pointed out that this was the abuse of discretion standard. He said that he would still affirm what the district court did, but he disagreed with the district court that no one could possibly find this to be coercive, and that therefore it's not a serious question. He thought that a serious question had been raised, and so therefore the PI question should have been analyzed under the kind of the traditional rubric. And I thought it was great. And, although as kind of heartening as Judge Bennett's concurrence was, and one that I think was probably just exactly correct in every way, it almost made me that much more troubled by the majority opinion, right? Because presumably the other panelists saw the concurrence before issuing their opinion, which means one of two things happened, right? Either they saw the concurrence to kind of politely encourage them to not be so far out in left field, and they just completely disregarded it, or they saw the concurrence, and what we're reading now is actually the toned down version, and the earlier version was even wackier. I don't know which one is worse, but what I do know is I appreciated Judge Bennett's concurrence. I agreed with it. I don't even necessarily think the majority opinion got to the end result at the end of the day. But just the dismissiveness and just the glaring blind spots that permeated that opinion really bothered me.
Christy, have you received a letter from Elizabeth Warren in the mail suggesting that you be quiet? Would you treat that letter seriously, like it had some kind of consequence?
If Elizabeth Warren was still a sitting senator, I would definitely sit up and take notice for sure. I don't get letters from my senators very often besides when they ask me for money. But if they were sending me a letter for a purpose of other than asking me to give to their campaigns and telling me to be quiet, I might, respond accordingly. And I think that point, Anthony, is really an important one, because senators and other public officials send letters all the time. And they kind of allude to this a little bit in the opinion, that various public officials will send and send letters to people expressing their opinions regularly. And it is a fact question on how coercive that letter is. So I'm with Justin here, and that Judge Bennett got it right, that it's a little too on the nose to say they didn't even raise a substantial question at all, but maybe there's not a substantial likelihood of success. And I'll add this other observation. I think this case kind of embodies this larger trend of trying the whole case at the PI stage, that we're seeing so much of these days, that the PI decision really takes the wind out of the rest of the case. It's awful hard to continue litigating after the Ninth Circuit has effectively said you don't even raise a serious question. Mm-hmm. And so it makes litigants have to have their entire case ready to go when they file. There's no, let's see how this plays out. Let's see what the witness testimony looks like after you've uncovered things. Your whole case has to be packaged almost when you start. Otherwise, they could kick your complaint.
Right. Yeah, I had a similar thought about the PI standard, and I think you guys both make really good points about maybe the concurrence was the best way to go in this case, because it doesn't kind of poison the well of the rest of it. I had not thought about the Bantam Books case, I think probably since law school, because I just haven't kind of come across this kind of situation in my own work since then. And so it's funny, Justin, you describing all the problems. I'm kind of starting at this almost from the ground up, because it's been so long, about how this type of situation should be treated under the First Amendment. And it seems to me, it could be that this is pretty basic stuff, but it seems to me that there's a huge difference in whether you treat it from a subjective standard or an objective standard. Because if it was Amazon that was responding to this and not the actual plaintiffs, who would have, even better standing because they were the one the letter was directed to. Amazon has very sophisticated attorneys who work for them and businessmen, and they would understand that.
And women.
She is, sorry?
And businesswomen.
Businesswomen too, of course. And she would understand, they would understand that she is just one of 100 U.S. senators, actually doesn't have power, that she's a blowhard and says stuff like this all the time to all kinds of people. And of course, all public officials do that a lot. And so, they probably weren't too concerned about it, though it does seem like they did respond to her actions, and because God knows what else was going on in the executive branch at that time. But if you were, say, you put yourself in the shoes of just some lowly author or a bookstore, someone who's not sophisticated, let alone a lawyer, and they get a letter like this, I mean, they don't know all the intricacies of if that's a word, of how the U.S. Senate works, let alone the federal government works. I mean, they just know she's a powerful person. They get this letter. They're going to respond probably differently than someone in a sophisticated party that, knows that this is just some noise. And so I think a lot, and I don't know, frankly, where the answer lies there, but I think a lot depends on that. And that probably, when we're thinking of put a First Amendment hat on, we should be thinking of what the kind of more average listener is going to be listening. Think of this than the more sophisticated types.
Yeah, I hear your point there, Anthony, but I also think it has to come down with whether a person is thinking that it's the power of the government, because Elon Musk could tweet out a whole bunch of bad things about a given book, and if nobody's going to be confused that it's the power of the government that's coming down on you, then no problem under the First Amendment. The real issue comes in here, given Senator Warren's power as a government official and her role on this committee that Justin rightly points out that they relegated to a footnote. Because if she was an ex-senator and, she's just, paving the way for future campaigns, that's a different story. But she has at least arguably the cloak of government power in writing this letter, and that's where there's at least something to think about.
Yeah, and I think it might be a case where there's really isn't an easy answer sometimes. Like, what if it was someone who just works for the government, has no power, sends a letter, but the receiver doesn't, know how whatever level we're talking about, state, local, federal government works, versus someone who is, the actual enforcer of the law. And so I think, in this case, she's obviously cloaked with what seems like a lot of power, even if she's just, as we all know, 1/100th of 1/2 of one branch of the government.
Right. And it does matter. And the court does talk about how it matters who's the one sending the letter, right? Whether that person has unilateral authority to enforce.
Yeah.
But I would argue this also illustrates a problem with the underlying precedent, which is I don't think the precedent really grasps yet, at least, the point that it perhaps takes less coercion to get a seller of someone else's book to stop selling that book than it does to get the primary author to be quiet. And so, if you're looking at it from really any bookseller's point of view, especially a large bookseller like Amazon with, huge potential liability that they're always worried about and they're always trying to manage their risk, you get a letter like that, even if it's not the type of thing that would make some people be quiet, you got to realize from Amazon's point of view, they're going to be like, well, this is not worth the headache. This is not worth, making the government mad at us. It's just one out of countless books. And so I think the precedent needs to reflect that fact when you're dealing with this kind of third party aspect of censoring someone indirectly instead of directly, that I just don't think the precedent fully deals with yet, but should.
Well, we're going to be moving, thank you for that discussion, Justin, but we're going to be moving from letters and books to jackets. And I'm sorry, this is not about fashion. If you're worried about what the latest jackets for the fall catalog are going to be, but Christy, we had this incident with a jacket in Texas, and apparently the guy still wanted it, and that is a key fact for the case.
Yeah, so we're looking at the United States versus Ramirez. It's a case out of the Fifth Circuit. And I am going to give this case the tagline, "Stash it at your mom's house," for reasons that will become apparent as we talk. And this case concerns an appeal of a criminal conviction. So we're moving from the civil world with Justin to the criminal world, and the denial of a motion to suppress. And like most motions to suppress, it's really the whole ball game when you come to the criminal conviction. If the evidence is allowed to be considered, the criminal conviction is going to really stand. And in this case, the defendant, Ramirez, was charged with the crime of being a felon in possession of a firearm. So, spoiler alert, whether the gun should have been part of the evidence or not is the kit and caboodle. And Ramirez claims that the gun was only found because the officer who found the gun violated his Fourth Amendment right to be free from an unreasonable search, and therefore it should be excluded. Now, the facts of the search are where we get into those jackets, Anthony, or a jacket rather than multiple jackets. A police officer here was told to watch for a truck registered to Ramirez's mom. And we don't really know the backstory of that, but we know that he was supposed to be on the lookout, bolo, for Ramirez's mom's truck. And it's enough to say that the officer was basically circling Ramirez's mom's house. And eventually, the officer saw the truck, which was being driven by Ramirez, pull up, and saw, allegedly, Ramirez roll through a stop sign before pulling into his mom's driveway, and then the officer made a stop. as the officer was making the stop, Ramirez got out of his truck, or his mom's truck, and the officer saw Ramirez walk over to a fence on the mom's property, and then toss his jacket over the fence and into the mom's yard, and it landed on top of a closed trash can. Long story short, after detaining Ramirez, the police retrieved the jacket from the mom's backyard, and then they found the gun in the pocket. The majority in this case, Judge Elrod, and she was joined by Judge Dennis, they held that the search of the jacket violated the Fourth Amendment, and the district court should have excluded the evidence of the gun. And one of the great noteworthy things about this case is that the majority examined this Fourth Amendment case under both the reasonable expectation of privacy framework and the property rights framework. And they concluded the essential question was the same. Was the jacket abandoned? And I think you can see where this is going. No, the majority says he did not abandon the jacket because he was looking to go back and fetch it at some point. And putting the jacket on the other side of the mom's fence didn't mean that he intended to give up all the rights to the jacket ever. He placed the jacket on the other side of this fence so he could hide it, so he could keep it safe. And the fact that it was his mom's property was important. It wasn't a public thoroughfare. It wasn't a bowling alley like there has been in another case. He was trying to put it at a place where he had a ability to go get it and it would be safe. And there was some evidence that Ramirez ate meals at his mom's house and checked out his mom daily and got his mail there. And so, that's all part of the idea that this was someplace he could store stuff. And this case is kind of particularly noteworthy because it shows that this reasonable expectations of privacy kind of theme or analysis might just be really about whether you have a property right in something or not. And maybe, perhaps one day in the not so distant future, the whole is there a reasonable expectation of privacy analysis will no longer be the way of thinking about things. And instead, we'll just look to whether a person has a property interest in the item that the government is looking to search. And then if we do, you can't just search it. So that's kind of the hope of that analysis and what this majority framework kind of suggests. Judge Ho dissented from this opinion, and he would have concluded that Ramirez had abandoned his jacket. And he kind of rests this conclusion on two points. The first, the mom's backyard was easily accessible by the public. And the second, that it landed on the trash bin. And as we all know, you don't have a reasonable expectation of privacy in your trash. Whether that's right or not, that's kind of the law there. Ultimately, I agree with the majority. Ramirez didn't intend to abandon his jacket. He intended to stash it. He intended to hide it from the police officer. And it can't be that the police can just have the power to search your mom's backyard because you got pulled over outside of her house. But I am troubled, for lack of a better descriptor, by the consequence of this case, that it's okay to stash some contraband close by if you think the police officers might search you. And that's fine as long as they don't have a reason to search that additional spot. And I'm going to say this, I'm especially troubled by the fact that it's okay to stash contraband on your mom's property and find this ruling coming out right before Mother's Day. I think that is a problem for the court to be telling folks that they can stash their illegal stuff at their mom's houses right before Mother's Day. That's just not a kind thing to all mothers out there.
I disagree. I think it'll motivate people to be even kinder to their moms in case you need to use their property to stash your stuff, or maybe I have different stuff than you guys do.
Reminds me of Joe Pesci's mom in Goodfellas and how he used to use her house. So maybe a similar thing. Justin, do you ever stash jackets at your mom's? And what else do you think about this case?
So sometimes I do leave things at my mom's house, but it's rarely to avoid the police.
Okay.
I basically agree with everything that Christy said. I did agree with the majority opinion, but I actually liked Judge Ho's dissent as well, even though I respectfully disagree with his conclusion. And what I liked is that both the majority opinion and the dissent were really engaging with the facts. Now, they were prioritizing different facts and coming to different conclusions, but I think this is the type of situations where reasonable minds can disagree, right? Because on the one hand, right, it's his mom's property, right? And I do think that there's a good chance that he intended to wear that jacket again, provided that the top of the trash can lid was not all grimy or anything. But on the other hand, right, that it was on top of trash cans. It was next to a sidewalk on the edge of the property. Now, of course, the majority opinion points out that there's a fence between the trash cans and the sidewalk, but the dissent points out, well, it's a chain link fence, right? And not that high, right? So it's like you've got these competing facts going back and forth. You know, it's on his mom's property on top of a closed trash can separated by a fence. And then, but it's on top of a trash can. Unfortunately, neither opinion talks about how dirty the top of the trash can is, which is something I would have liked to know. You know, where someone can kind of reach over when they're walking down the sidewalk and grab it. And so I was really left with two kind of thought experiments, right? One was, well, if a stranger's walking down the sidewalk and they reach over that chain link fence and they grab the jacket off the top of the trash can, is that theft? And I think it is, right? I think it is. I think that there is still that retained
it's theft
property
if they
interest
take your trash.
Well, there you go. That too. And then the second one is, was he really planning to wear that jacket again? Maybe, but again, I wish one of the opinions had talked about how filthy or not filthy the top of those lids were. But I think the majority got it right. You know, and I'm glad. You know, I think regardless of whether, you know, the thing about these constitutional issues is, right, you can't let yourself get too bogged down by any one case. You have to think about the broader implications of the precedent. And I think that the rule coming from this case is the right one, both as a matter of constitutional law and as a matter of people, you know, being extra nice to their moms in case they need their property. And so I'm glad the majority opinion, you know, came out the way it did. But I do want to give kind of a shout out to Judge Ho with his dissent, that even though I respectfully disagree with his conclusion, like, he was engaged with the facts. Both sides were engaged with the facts. And when you have kind of reasonable minds both engaging in the facts and kind of engaging in a good faith debate, it really helps to illuminate what's going on and helps to explain things to the reader. And so I just enjoyed reading this whole thing.
So with all due respect to both of you, and also I will include Judge Ho, I am actually flabbergasted that it can even be considered a close issue. I think the majority was absolutely right. And I think the government seems to have completely botched what they were arguing. And I'm actually, I'm in some ways, I'm worried about this defendant. You know, he may be a terrible person in real life, but considering they need this evidence to convict him, a little worried about what's going to happen to him on remand, considering the victory he just had. So the action of putting the jacket over the fence, even if it's to try and avoid a search, right? That shows he's not abandoning the jacket, for one thing. It's on his mom's property. And maybe the only thing that kind of gets close is that it's on top of the trash can. But like, this all goes back to this case that we at IJ sometimes rail about trash being abandonment, right? And so this case where the trash cans were, I think they were set out for the garbage truck to pick them up. The cops go up, technically are on the edge of the property, right? But it is set out for a trash company that's going to come and take it anyway. And so they look through the trash and find evidence. These are, as far as I can tell, these are trash cans that they're sitting on the mom's property, but it's not like they're at the curb. They're on the other side of the fence. So how does the fact that they're trash cans really factor into it at all? What if they were taken?
Well, Anthony, let me ask you a key question that neither opinion answered. Let's say, for the sake of argument, these are like really old, grimy trash cans with really old, grimy lids and like other trash kind of piled on top of it, where no reasonable person would want to put that jacket back on after it was sitting there in that filth. Would that change your analysis at all?
Not
really. At all.
I mean, you can wash it.
Well, yeah, you could wash it, or say there weren't trash cans. Say it was a mud puddle. and I throw my jacket over the fence and it goes in the mud puddle, it's still on private property on the other side of a fence, right? Fences make good neighbors. We all know about fences and property rights. And so if like a stranger walked down the street and took that jacket, that would be theft. So if the cops do it, I think it's also theft. I think the only thing that even gets close here is that, as Christy pointed out, it seems like it was pretty obvious this guy did this in order to avoid a search. And so does that in some ways, give them license to trespass on the property to get it? Like if he had got out, looked right at the cop, taken something and thrown it over, like maybe it was obviously a bag of cocaine, and threw it over the fence. But you can't go find if it's cocaine because I chucked it when you had already legitimately started to seize me. Is that different? Yeah, but that's not how they analyzed it. And then the thing I was hinting at when I began about what's going to happen on remand is there was no argument here about whether the Fourth Amendment didn't even apply, right? And so what I thought they were going to get at is that, was this an open field? Because they didn't talk about the curtilage, whether this is in the curtilage of the house, and if it's not the curtilage and it's definitely not inside the house, then it's, an quote unquote open field, which we at IJ are no fans of, and this doctrine, and therefore the cops can trespass. And under the Fourth Amendment, it is not a search and get the jacket. But of course, it's an effect, not a field, so that it gets into that. Anyway, what I'm afraid of, it just says that it's remanded. The guy's in jail right now, and I bet what's going to happen on remand is then they start arguing about whether there's an exception to the Fourth Amendment. And like, you could have done that on appeal, and if you didn't, I hope that they're just stopped from doing that and the guy's let out. I think, knowing the little I know about federal criminal practice, I think that's not going to happen, and he's going to fester in prison for a while longer.
Yeah, I think you're right there, Anthony, that the court was leaving open for the government to try again when they went back to the district court. I mean, there's a great footnote that they dropped in this case that is quoting an exchange with Judge Elrod, which is basically like, government, wink, wink. This is all you're going to argue? Really?
Right.
So I think they're trying to signal to the government that, hey, go back and try this again. And you've identified for the government, Anthony, some additional arguments they might make. I'll also say that I want to continue a little point that you made at the beginning of talking there, Anthony, that you don't necessarily abandon all of your privacy rights and your property rights by putting something in your trash can. That shouldn't be the way the law is, that if you put something in your trash, it then is fair game for the world to know about. There's all sorts of privacy things, medical records, financial records that we just throw away all the time. And it shouldn't be that once you relinquish it from your house and you put it in your garbage can, that it's okay for the world to know about it too.
And I think if that actually, gets up to the Supreme Court at some point and goes through this property rights framework, which the court also looked at, I think that garbage case, I think there's a good chance, especially with some of the justices on the courts now, that garbage case comes out differently through a property rights perspective, where like, I have a contract with the garbage company, they're going to take my trash, but that contract does not allow just anyone walking past to like stick their hands in my trash can.
Yeah, but what if it's the government doing the garbage service? Right? What if they work for the government?
Yeah, well, then I want that contract to not have a cops can do whatever they want provision. But
I don't think I have a contract with the people who pick up my garbage.
I have one with mine. They raise the rates every year. I think I entered into it years ago when we moved here. But well, anyway, we should do a show about garbage sometime, because I can see there's a lot of ins.
Or maybe we should find a case about garbage to do it again.
Well, if someone does, please let Josh Wyndham and Rob Fromer know, our Fourth Amendment experts at IJ, and we can go from there. Well, thank you both for coming on to talk about Elizabeth Warren and jackets, in funny way in that order. We will have another show next week that I'm very excited about, but no spoilers. But please tune in. But in the meantime, I hope that all of you get engaged.